Okay, so welcome to the fourth meeting of 2025 of the Economy and Fair Work Committee. The committee has asked item number 1 to agree that item 7, consideration of correspondence from the Deputy First Minister on the budget for 2025-26 is taken in private. Are members content with that? Yeah. Okay, our second item of business is an evidence session on 4 Scottish statutory instruments arising from the Movable Transactions Scotland Act 2023. 2 of those are affirmative instruments, the Movable Transactions Scotland Act 2023 Amendment Regulations 2025 and the Registers of Scotland Fees and Plain Copies Miscellaneous Amendments Order 2025. And the other 2 are negative instruments, Movable Transactions Forms Scotland Regulations 2024 SSI 2024-379 and Movable Transactions Register of Assignations and Register of Statutory Pledges Rules Scotland Regulations 2024 SSI 2024-381. Can I welcome our panel this morning? Ivan McKee, Minister for Public Finance, Camilo Arendonda, apologies if I got your name wrong, but Solicitor, and Jill Clark, Team Leader, Private Law Unit at the Scottish Government. And we've also got David Robertson, Policy Lead for the Registers of Scotland. As the instruments are all linked, this item is an opportunity for the committee to discuss all 4 instruments with the Minister and his officials before moving to the formal procedure at the next item on the agenda. I would stress at this stage there's no need for any motions to be moved under this agenda item. That will happen at the next item. So can I invite the Minister to make a short opening statement?
Great. Thanks very much, Convener, and good morning, Committee. And thanks for inviting me along to give evidence on these SSIs which relate to the Movable Transactions Scotland Act 2023. The Act is derived from the Scottish Law Commission's report on movable transactions. The first SSI, the Movable Transactions Scotland Act 2023 Amendment Regulations 2025, does a number of things. Firstly, it ensures that the definition of insolvency contained in the Act is appropriate in line with the overall policy intention of the legislation. It also makes necessary minor and technical amendments and corrections to the Act for the purpose of giving full effect to the Act as intended. The Minister for Community Wealth and Public Finance, who led the Act through its parliamentary stages, signalled at Stage 3 that, in light of Stage 2 non-government amendments to the definition of insolvency and subsequent government amendments at Stage 3 to modify the amended definition, there would be benefit in taking time to consult further in order to get this right, and that the powers in the Act could be used to make any necessary further amendments. So the changes to the definition of insolvency before us reflect that consultation. The other changes are essentially technical in nature and arose from further scrutiny of the Act after it had been passed. Some inconsistencies were identified and these amendments ensure that these are addressed. Turning to the second SSI, the Registers of Scotland Fees and Plain Copies Miscellaneous Amendment Order 2025. This sets the fees that the Keeper of the Registers of Scotland will charge for use of the Register of Statutory Pledges and the Register of Assignations and the provision of copies and extracts. These are 2 new registers established under the Act. The fees were consulted on by Registers of Scotland last year at which time a registration fee of £80 was proposed based on the principle of cost recovery. That was using estimates of registration volumes derived from detailed stakeholder engagement over a number of years. Respondents viewed the proposed fees as prohibitively high and excessive to the extent that the registers may not be used and the legal reforms intended by the Act could be impacted. The consultation prompted further engagement between Registers of Scotland and key stakeholders. This engagement allowed more detailed information on the likely usage of the 2 new registers to be obtained. This allowed anticipated volumes of applicants to be revised upwards, resulting in the lower ROA registration fee of £30 set out in the order, with a £30 registration fee for an initial or single statutory pledge within a statutory pledge document and a £5 fee for each additional statutory pledge for which a separate registration application is made. RSP corrections, which include discharging statutory pledges from the register and correcting mistakes introduced into the register by the applicant, are kept low at £10. It is hoped that these fees will encourage users to maintain entries for statutory pledges over time, ensuring the register is accurate and preventing it from becoming cluttered. Fees for plain copies and extracts are in line with what the Keeper of the Registers of Scotland charges for the other registers under her control, and searches of the 2 new registers are charged at £3 per search under the existing Registers of Scotland fee order. The third SSI, the Movable Transactions Form Scotland Regulations 2024, provides for the form of a pledge enforcement notice and a correction demand respectively for use in relation to statutory pledge as created under the 2023 Act. And the fourth SSI, the Movable Transactions Register of Assignations and Register of Statutory Pledges Rules, Scotland Regulations 2024, sets out rules for how the 2 new registers will operate on a practical level, including the making up and keeping of the registers, procedures in relation to registration and correction, and the form of documents and information to be used in connection with the registers. Of particular note, the regulations say that both registers will be electronic in their nature and provide for the information applicants will be required to provide when making applications for registration. I'll be, of course, happy to take any questions on these SSIs. Thank you.
Thank you very much, Minister. Can I open it up to members' questions? Murdo Fraser.
Thank you, Convener. Good morning. Minister, I have a mild fascination with this subject, dating back to my days in legal practice. And just to put it in context, I can remember being instructed by an English-based bank which had been approached by an impoverished Scottish farmer, not Jamie Halcrow Johnson, I should hasten to add, and they were prepared to lend him some money, and he'd offered as security a flock of sheep. And I had to try and explain to this institution that they could not take security over the flock of sheep unless they took delivery of the flock of sheep, which is not something that was of interest to them. So I'm delighted that the law has now been reformed to make such processes more simple. But it does, of course, throw up a range of other issues that I think we need to consider carefully. Can I start by asking you about the change you referred to, about the change to the definition of insolvency that came out of the consultation process that the Scottish Government ran? And you referred to the responses. Now, the responses haven't been published, so we don't know what else was in them. So what I'm wondering is, firstly, is there any reason why you haven't published the consultation responses? And secondly, was there anything else in the consultation responses that you considered but decided not to change at this stage?
It's a good question, and I'm going to defer that one to officials just to understand. I myself haven't been through those consultation responses in detail. So who wants to pick that up, Jill?
Yeah, we haven't published the responses, but we'd be happy to do so. It wasn't a kind of formal consultation. It was quite a short 1-month targeted consultation to kind of people who were specialised in that area, which is the reason that they have not been published, but there's no reason not to. And we were obviously asking them about the definitions as they stood in the Act when it was passed. And there was a variety of responses on whether the definition should be kind of wide or narrow. And they kind of were fairly split. And we were content that where we'd got to by the end of Stage 3, which followed Stage 2 amendments, which were promoted by the Law Society, and then further Scottish Government amendments at Stage 3, that we were probably in the right place. But the anomaly was that debt arrangement schemes were included in the definitions, and that these are not insolvency procedures and therefore should be removed. We consulted with the accountant in bankruptcy about that, and they agreed that it should be removed as well from the definition. So that's what the amendment does. But yeah, more than happy to publish the responses.
Thank you. I mean, I think that would be of interest to the committee, just to see if there are other issues, perhaps, that we could look at in future. I suppose to widen the point slightly, we had a discussion in private before you came in about some of the issues that are thrown up by the legislation. In particular, I think the issue of the risk to a purchaser of movable property, whether that be a consumer or whether that be a business, perhaps not aware that the law has changed in this area, perhaps not aware that whatever they are purchasing might be attached, might have a charge against it, because that simply hasn't crossed their radar. How much has the government done to kind of raise awareness or create publicity for those who might be impacted by it?
No, that's a good point. I mean, clearly, officials can comment as well, of course, but the register would make that information easily available for anyone that chose to search for it. But you're absolutely right, raising awareness of that change is important. So what have we done specifically?
Yeah, I mean, in the couple of years since the legislation was passed, there's been a lot, I would say, of legal articles about it, publishing what's coming, and there's been events and seminars that have been run by the commissioners who wrote the report, and practitioners who worked on the group that supported that. So we've gone along to those. So there's been quite a lot of events, and then David might be able to describe better what's happened via the registers, but there's been ongoing engagement with stakeholders there as well, and there'll be guidance and marketing of it.
Yeah, that's correct. There will be full guidance available on our website, and there is a short marketing campaign which is currently being planned and to be targeted so that people can become aware of the existence of the registers. I'm not sure that it's publicly known. It's obviously professionally known within the profession, but publicly less so. So we're currently engaging.
I mean, I guess that would be my concern. Is, I mean, clearly raising awareness amongst practitioners is one thing, but not everybody purchasing something movable would necessarily involve lawyers in that transaction. So you may get, whether it's a business or a consumer, parting with quite a large sum of money for something, then realising after the event there's a charge on it.
That's a very good point, and I think you're right. The engaging with the profession is one thing, but as you say, in many cases, legal support wouldn't be engaged in those transactions. So I think we'll take that away, and I'm very happy to look at how we can do that more comprehensively through business organisations or more generally to see how we can raise the profile.
Yeah, I think that'd be helpful. I mean, there are consumer groups, for example, who I think would help spread the word. Okay, thanks very much.
Thanks very much, Murdo. Can I just come back to the point on the consultation? Probably a question for Jill. Obviously, you're going to publish those consultation responses, which will be helpful. But obviously, as a result of the consultation, there's just one proposed change. Was there any issues raised in the consultation where you rejected a change, for example, that was picked up in the consultation? Was there an ask for anything else, or is everything covered by that one change, do you think?
Yeah, as I say, there was differing views as to how wide or narrow the definition should be, but there was no consensus on that. So that's why the only change is this. There is a power, obviously, that we use just now and that we can use in the future should the landscape regarding insolvency or bankruptcy change. The definition can be further amended going forward if that's the case and if there's consensus for it. And just one point about the awareness is, of course, consumers and individuals were removed from the ambit of the legislation at stage 2. So it is very much focused on businesses as opposed to individuals.
Okay, thanks very much for that. Okay, can I bring in Daniel Johnson?
Thank you, Convener. I'd like to ask questions about the fees order, and I should like to begin by thanking Murdo Fraser, because I think the flock of sheep actually serves as a useful example, and that if you are the shepherd wanting to borrow against the flock of sheep, it needs to be cost effective to register, but actually critically to update, so that if you maintain accurate information against in terms of what the asset currently is that's being borrowed against. So can I just ask about the schedule of charges? Obviously, you set out that following consultation reduced the registration fee from £80 to £30. Can I ask how that £30 level was arrived at? And does the government feel that is right, given that the Law Society in their submission have pointed out that in other jurisdictions, the registration fees are considerably lower. So, for example, they offered the example of Australia and New Zealand, where the registration fee was in the region of £7, or comparable situations in terms of registering mortgages or charges over a company's assets. And company's assets is charged at £15. And while I understand that £30 is not an astronomical amount of money, it's still more than those sums. I just wondered, how was it arrived at, and what is the view of the government in terms of what the level of fee does in terms of maintaining that accurate register?
Yeah, so there's a principle there about And if you look at Register Scotland in general, it effectively brings in enough revenue through its various activities to cover its costs, which, of course, from a public finance point of view is very welcome. And I suppose that's the principle we operate to understand what the cost of running the service would be, the number of transactions are likely to be, and use that to arrive at a fee or a fee structure that allowed the registers to cover their costs as a consequence. The initial £80 was based on an estimate of the number of transactions. It was then revised as more work was undertaken to understand more thoroughly what that would look like. And I think that we estimate about 25,000 transactions or thereabouts over the period of a year once the system is up and running. And if you do the calculations on that with their estimated running costs of closer to £1 million when everything's up and running, then you come to that schedule of charges. So that's why it's there. It's clearly getting that balance right between what is something that people will feel that is reasonable, and obviously extensive consultation was taken on this, and there was many of the points you raised were made, and that was part of the reason also for reducing the £80 to £30. But as you said, I'm not quite sure how many sheep £30 will buy you, but in the big scheme of things, if you're running what will be sizable transactions with many other fees involved as well, in terms of obviously borrowing against those assets, then I'd expect that this number would not be a significant issue. Of course, as we move forward, there's scope to revise these fees as well, depending on if there's more transactions coming through or less, or how we see the costs working through.
So, I mean, could I just ask on that point? I mean, is it sort of, is that actively programmed in to assess and review the fee structure once it's up and running? It's
something that the registers would obviously, the keeper would be watching as part of their ongoing business and the engagement she has with ministers, and the same would apply to the whole range of fees that they offer, they charge for various services. So I don't think there's any specific trigger for that, but there would be a process, I think, annually, whereby there'd be the opportunity to be able to engage on that.
Yeah, that's correct. We review fees annually. We'll be keeping a particular eye on these two new registers, obviously, in the first couple of years of introduction.
And you alluded to in your statement about the cost for searches, and that's obviously a really important element of the whole system, that people can quickly look at what registrations there may be. Now, I note that when the legislation was progressing, there was some discussion about providing free access to non-profit money advisors. And I understand that hasn't come forward. I just wondered what the government's thinking on that position was.
Is that not come forward in
to be honest, I don't have the answer for that one.
Okay.
Ready?
I could perhaps answer that. In so much as it was linked to individuals being able to take advantage of the Movable Transactions Act, and they were removed at stage 2 because consumer advice agencies raised concerns that it might open them to sort of bad lending. So there are no individuals can't have a statutory
I wasn't asking about individuals. It was so the specific point.
That was why money advice bodies might have had free access to the registers to check on behalf. If they were sitting with a client, they could have looked at the register, but individuals won't be able to use the register.
So, sorry, can I clarify? Are you saying that not-for-profit money advice organisations will be able to search the register?
They'll be able to search the register.
And do that for free?
Not for free.
Because my understanding was that was what had been discussed when the bill was progressing.
So I think the distinction is that when the scope of the bill included individuals, then there would clearly have been a case for money advice organisations to be able to access the registers to operate on behalf of individuals that may be making use of the register. But with it now limited to businesses, then I think the feeling is that there's not the need for debt advice agencies to act on their behalf. Is that?
Yes.
Yeah.
I mean, can I just ask an associated point, which is not directly related, but I think it's related to this broad point. So the one point is about the fees. I think the other point is just the accessibility of the register, especially to businesses who maybe not necessarily engaging armies of expensive lawyers? Just what work has been done to ensure that this is a register that is easy to use, accessible to businesses that might seek to use it?
It's a good question, and I think I'll undertake to go and log in myself and see how it works, just to verify that. But certainly from my personal experience, and others may have other comments on that, but making use of other registers that Register of Scotland provides, I find it would be very easy to use and very accessible.
Yeah. The citizen will be able to make their own applications through the online registration system. It's open to professional users and non-professional users.
Great. Thank you very much.
Thanks, Daniel. Can I come back on the point about the fact that the fees order doesn't make any mention of not-for-profit money advisors being able to search register for free? I mean, a money advisor may advise a sole trader, for example, and it's my understanding that it is a legislative requirement that not-for-profit money advisors can access the register for free. So how will that be achieved if they're advising a sole trader, for example?
Right, it's a good point. I think the best plan is maybe we'll take that away and come back and reflect on that specifically, because, as I said, when individuals were taken out of the scope of the bill, the sense was that there wasn't that requirement, because that's clearly where the vast bulk of debt advice, money advice agencies would be operating. But you're right in the sense that a sole trader could find themselves in that position. So I'll go and check what that situation looks like at the moment. And also, I don't know if we've got any data on how many of those searches we might expect money advice organisations to be undertaking, but I suspect it wouldn't be a big number in the big scheme of things. So we'll go to reflect on that and engage with the register, with the keeper, and respond to the committee on that.
Okay, thanks very much for that, Minister. Can I bring in Lorna Slater?
Thank you very much, Convener. I've got several questions, but I'll put them into two clumps, if that's all right, Convener. So I'm asking questions about the rules around the new regulations around making up and keeping of the registers. So with no requirement for verification or update of the registers, how can accuracy be assured and fraud be prevented? How are out-of-date entries removed, for example, when a debt's been paid or the pledge is sold? And how are registers updated if the pledge is transferred to a different creditor?
Yeah, clearly there's provision there for that to be done. I suppose your question is, why would people do that? And I suppose there'd be an interest in people keeping, on both sides of the transaction, keeping that up to date, because it obviously reflects the commercial reality of where they're at. But I don't know if you want to add any further comments on that.
Your last question is regards how the transfer of a pledge, that would be an assignation, and that would be done through the correction procedure. Traditionally, in other registers, it might be done through a registration process, but it's not a registration trigger event, so it's not something that has to be done. It's an optional. But if the parties want to keep the register accurate, then they would be expected to register the assignation through the correction procedure, and that's open to professional users and non-professional users to do that. Can I ask you what your second question is?
So yeah, so it was around in keeping the register up to date in terms of when entries should be removed, so the item, the pledge has been sold or the debt has been repaid.
Again, there's two means that can be done. It can be done through the correction procedures, which is the main one is the secure creditor is expected to keep the register up to date. They're not obliged to keep the register up to date. It's an optional thing, but there's an expectation that for all engaging with the registers, that the registers to be up to date would make sense. If they don't update the register, there is an approach whereby the person who grants a statutory pledge, they can write to the secure creditor, ask them to update it, and if they don't do it, then they can issue a correction demand to the keeper, and the keeper will update the register if the secure creditor doesn't challenge that at court.
So keeping update, there's no fee incurred for keeping the register up to date?
There's a £10 fee for keeping
There's a £10 fee for keeping up to date. So that is on the creditors and the debtors, as it were, the person who's made the pledge to keep track of it?
Only when the debtor asks the secure creditor to amend the register, and they won't do it.
Okay.
For whatever reason that is, they can then issue the correction demand, and then that goes to the keeper, and there's a £10 fee for that.
So the responsibility is really with the creditor, except as you're saying, that's optional, it's not mandatory.
Yeah, the SFC originally looked at whether it could be made a mandatory thing, but they thought, no, that has to be optional, but there's the expectation that reputational financial institutions would have an interest in keeping the register up to date.
Okay. Is there any particular reason why they couldn't make it mandatory?
I can't recall the answer to that. But
I would be interested, maybe you could write to us with that, because I think that's an interesting point about we all want to make sure the registers are accurate, and you can imagine a small business person who needs their asset back, not being able to get a hold of that. So the second group of questions is around, is there enough information in the register to identify those carrying out registrations, especially if they're out with the UK? How do we make sure that that actually identifies the person who can be contacted or the business? If third parties are doing the registering, how do we ensure that they have appropriate permissions to do so and ensure privacy of that information that's being shared? And finally, how can third parties or people find errors in the register correct the errors? You've mentioned the correction procedure, but is that available to a third party?
if the error affects them, then it will be available to them. If they are, for instance, if they're a provider, a third party. If a third party is listed as a provider of a statutory pledge and they're not, they can go through the correction demand procedure.
Okay.
So yeah, it's open to a third party to do it who's incorrectly been listed, or someone who has an interest in the property over which the statutory pledge has been granted. And the register says that that's the property the statutory pledge has been granted, but the statutory pledge shouldn't have been because it's property that belongs to a third party. They can challenge that as well and have the register corrected.
And who adjudicates that? Because presumably the register doesn't adjudicate that if there was a dispute.
We don't. The procedure is that they have to write to the secure creditor to ask them to correct it. And if they don't, then they'll write to us. And we serve a notice on the secure creditor to say that we're going to correct the register in 21 days to do whatever it is that we've been asked to do. For instance, remove a provider who's been incorrectly listed. And if the secure creditor don't get back in touch with us to tell us that they've challenged it in court, we will correct it in 21 days.
Okay, so yeah, so the first two questions were around identifying organisations out with the UK and whether there's enough information in the register to do that, and how do we ensure appropriate permissions have been obtained and privacy is protected for when registrations are happening.
The first one I can answer because the detail for all parties are quite considerable in the rules. It's quite technical, the levels of information that they have to provide, and the only difference if you are outside of the UK is that you don't have to automatically provide a company number that's been issued to you. All of the details are the same. The name, registered office, address, the comparable for UK and for non-UK, they're exactly the same. The only one that's any different is the ID number. If you're a UK company, you have to give a company number. That's mandatory. But if you're not a UK company, then we can't mandate the use of that because we don't know if there is one and we're not validating it. So that one's optional. But apart from that, the detail as regards the correspondence regime, who you would contact for the secure creditor or for the provider, it's quite intensive.
I guess there's an interesting question there about how that would overlap with international law if there's a charge against something that's owned by someone out with the UK because a Scottish business took out a loan against that. It wouldn't. I mean, is that the purpose of that registration?
It should be a Scottish asset. Right.
Okay. But it would maybe be owned by a.
Yes, it would.
Right.
Be.
Understood. Okay. And the point about the privacy. In terms of when registrations are going up there, whether they're accurate or in error, to make sure that the permissions for posting that information have been obtained in terms of
what we're doing is authenticating the user. Sorry, it's authenticating the applicant who makes the application. If you're a business user, then you may have an account with the Register of Scotland anyway. If not, there will be an onboarding process for our e-services. There will be a credit check. There will be almost certainly set up an ID, set up a direct debit for payment. So there's a number of checks that get done there before we'll accept an application or regard an applicant as authenticated. If you're a non-business user or a citizen, then we will authenticate your identity through Scot Account, which is a Scottish Government ID authentication service, and we'll also do a credit check as regards that.
So that's for the secure creditor who's going to be updating this, but they're putting in someone else's information, the information about the debtor in there.
That's correct, yes.
So how do we ensure that the information about the debtor is, that they have permission to put that up there in public space?
We haven't given, I'd have to respond right to you with the answer for that one.
Okay, thank you very much. Thank you, Convener.
But not putting that information, that's a necessary part of the process, isn't it? Because the whole point is to make that information visible.
Yeah, the rules provide that you need that information in order to enable searching. So
Yeah.
the register can't exist without that information. But we accept that from an authenticated user, then that information that they submit will be correct.
Well, yeah, I suppose that's true from the point of view of the secured credit, but you assume that they've obtained that information accurately from whoever they are, from the debtor.
That's correct. It would replicate what we do for all of our other registers. For instance, the land register solicitor will be the applicant, and they will submit, for instance, a disposition from A to B. And because they're an authenticated user, we will accept that they are entitled to act for B, but they're not acting for A. But there's obviously the professional aspect of the submission of the applications. We assume that the information is correct.
And we don't have any concerns about the fact that debtors' information is publicly available in this way. In fact, that is if I understand it, that is the point of having those registers.
To make that visibility,
yeah, to
so
make
that
that
people can
visibility.
search. Exactly.
I mean,
Okay.
the visibility needs to be there,
Yeah.
or else that's the
point. Yeah.
The key point of the registers is that if the information is not there, then the register is largely useless because you
Yeah.
can't search. And it's really the searching aspect for the due diligence for anybody who wants to lend or assess whether someone can borrow or make an assignation.
So I guess a debtor who then is putting a pledge forward needs to understand that their data then becomes visible publicly, and that is something they need to be aware of. All right, thank you very much. Thank you, Convener.
Okay, thanks very much. Can I bring in the Deputy Convener?
Good morning. Thank you for joining us. I just wanted to follow up one wee thread off the back of this. You mentioned there, David, about a credit check. Can you just remind me the nature of that credit check, because it's going to frame my question, because I didn't quite hear all that section.
Unfortunately, I can't give you any more details as regards what we actually do.
My question is, on whom are you performing the credit check in terms of this role play?
It would be the applicant, the person who engages with us. So the
Right.
applicant should be either
Okay.
the secured creditor or their legal representative.
Okay, so therefore, what tests have you done against the possibility of fraud? And I heard what you said earlier about the checking, but if that checking is predicated on an SC number that's been set up through Companies House, the problem we have is that it's extremely easy to set up a fraudulent body via Companies House. There's umpteen examples of Scottish limited partnerships in particular, and no checking is done via Companies House. So I appreciate it's a long shot, because you might ask the question, well, why would somebody go to the trouble of setting up and then putting in place a fraudulent transaction on the registers? But I just wanted to explore how much you can track that through, because in of itself, an SC number and the other associated detail doesn't mean to say that they're acting in good faith.
That is, if someone went to those lengths. I mean, what we generally do is most of our registered customers are either solicitors or legal, legally qualified person in some way. And part of the onboarding for issuing them registers accounts is we do a law society check. We do an independent verification that they are who they say they are. For other customers, we tend not to have non-business users and individuals making too many applications. When we're doing the land register, we do ID checks for fraud purposes, and that's largely what we're replicating for the movable transactions registers. The best example is if you're an individual, we will check your identity through Scott account, and they will check passport, driving licence, and a credit check will be part of that. I can't say exactly what's involved in that credit check as regards Scott account.
But there's a number of different scenarios in it. I'm just thinking about the example of Scottish limited partnerships, which has been written about a great deal. They are used for a variety of mechanisms, but the whole point of them is that they give the impression of probity. because you can see them registered in Companies House and they've got this brand, Scottish Limited Partnerships. And part of it is the footprint giving the illusion of legitimate activity, which actually is not at all. So I suppose I'm just not certain that you've considered all the potential fraudulent situations if your testing is predicated on a complete lack of testing from Companies House. Because the record has shown us that the volume of fraudulent companies is alarmingly high, and there's ample evidence of that. Scottish Limited Partnerships being registered to addresses in Dumbarton, like hundreds of them. And I suppose it's just, you might say, well, why would someone go to the trouble of doing that? But this is the essence of fraud. You suddenly go, well, somebody did, for reasons that we've not yet thought of. So,
I suppose the question is there an onus on the registers to verify information that they are presented with? And it's not even the information, because information will be accurate, it's the intent behind the information. And I suppose the answer is to that is the register can only check what's in front of them.
You can verify the applicant, and beyond that, because these are automatic registers, we can't verify anything else. If we were to verify it, then they couldn't be automatic registers, and it would take a lot more staff, and there'd be a massive cost impact in that. So the very nature of them being electronic and automatic involves no keeper validation aspect of it.
and I suppose that leads us neat circle back to the opening point about the veracity of the registers in general terms, about which a lot of the questions have been this morning, and also the rules and regulations that you know, there may well be scenarios, in fact a lot of them come out this morning, that haven't necessarily been thought about in great detail. You know, so I'll leave it there. I'll leave it there. But if you've got any further thoughts, feel free to write back to us. Thank you.
Thank you. Thanks very much, Deputy Convener. Can I bring in Murdo Fraser?
Thank you. I just want to go back, having reflected on some of the questions I asked earlier about protections for purchasers. I understand consumers are not covered by the bill because only businesses can grant pledges and charges. What happens if somebody buys from a business but not in the ordinary course of business? So let me give you, it's probably easier to illustrate with an example. So Mr. Halker Johnson, right, has a farm, so he's conducting a business. He's granted a charge over his movable assets, including his combine harvester. I decide I'm going to buy his combine harvester because I'm a collector of old combine harvesters. Am I, in that circumstance, protected, or would I need to search the register to make sure there's no charge against it?
There's not a requirement for you to check the register. You're still protected without doing that.
Because I'm not a business?
Yes, because you're an individual, yes.
All right, okay. All right, thank you.
Can I bring in Kevin Stewart?
Thank you, Convener, and I think that this section probably has opened up huge cans of worms in terms of possibilities, but it is our job to look at all aspects of this, and I'm interested in the corrections aspect of this, and you're probably not aware, but previously I asked a lot of questions around about fraudulent disposition of title and the difficulty around about correcting the register and doing what was right for people who had faced that fraud. The corrections aspect of this, and Lorna Slater probed earlier around about this. If there is a requirement for correction, if there has been, as Michelle Thompson said, a possible fraud, who is liable in terms of any correction or any compensation in all of this?
So in terms of who should make the correction or who would be liable if there was some fraud as a consequence of the entry
Kind
being
of both,
incorrect?
Minister, is
Okay.
what I'm asking. Yeah.
Okay.
As regards the liability aspect, the keeper wouldn't be liable. The keeper's specifically covered if it's reasonable for her to accept all information that's been given to her in the registration process and the collection process. So unless the keeper specifically makes a mistake in transferring information onto the register, or if there's some sort of system failure whereby a record gets accidentally removed, there would be no liability in the keeper from that because of the automatic nature of the registers. If someone makes a correction of the register, and if it's a fraudulent correction, the notifications get sent immediately to all parties who've been involved in the registration process previously to that. In the scenario of a statutory pledge, the provider would get a notification, the secured creditor would get a notification, and any email address that they previously supplied as part of the registration process would get a notification to say that the register had been corrected. And that would alert them to if there had been some sort of fraud as regard in a correction application.
Right, I'm playing devil's advocate here, Mr Robertson, but I think it's important to do it. If somebody highlights that there is a fraud and that a correction is required, who is liable if those notifications don't go out?
I'd have to check, but I think the keeper is liable for the notifications not going out.
Okay. Thank you. Thank you, Convener.
Can I bring in Lorna Slater?
Thank you very much. We talked a little bit about how but information accuracy for the creditor and the debtor. My question now is about third parties. So it may be that there are other documents that have been uploaded as evidence for the asset that's being pledged. For example, invoices that may have customer or individual information on that. In terms of customer databases as being proof of the value of the asset, how do personal information get redacted from that supporting information? So it isn't the creditor or the debtor, but the fact that you have all these customers is evidence of the asset. How is the privacy around that information, and how can that information be appropriately redacted?
Potentially commercially sensitive. So I'm assuming we don't put every single invoice onto the
documents
register.
Are submitted are uploaded automatically, and there's no validation of them. So there is a potential for a document to be submitted that contains personal information. The rules specifically provide for the redaction of that by the applicant before they send it in. We will have a robust process as part of the registration process that will have warnings on it. Do not upload anything that contains personal information. If anything has a date, the keeper will redact the date of birth from any extract or search. A full date of birth, we'll do the month and the year, we'll issue that, but we'll never issue a full date of birth as part of a search and extract, unless that is erroneously included within a document that's uploaded. Again, the whole automatic nature of the register, whereby you make your own registration application, you upload your documents. If you upload things that have sensitive information in them, then that can be publicly viewed. So we'll have a robust information process as part of the registration process to make sure that there's fair warning given to someone not to do that, and they probably should know not to do that, because we do that with our other registers, at least one of our other registers as well. I've got a register of deeds whereby if you register it, it will appear in the public register, but if it contains sensitive information, we will contact you and say, sure you want to register that.
Okay, so there's a check on the upload. If something, scanned document or something gets through that check, maybe I find out that my information's up there. Is there a method by which I can request a correction or a redaction of that information, given that I'm not one of the two parties that can do the corrections?
I think we would take that as there's numerous types of correction that you can make. There's one that's known as a manifest inaccuracy correction. That might be a route, but it might be a more appropriate route to contact the secure creditor to get them to replace the document with another document that doesn't contain the sensitive information.
That's clearly going to be quite a lot of work first, because in this case it would be an individual consumer, someone who was not involved in the transaction at all, who maybe just was a customer of them, to have to go to that secured creditor to get that. I think that's a bit onerous on the case of the customer to have to do that when they were in no way at fault around that. I wonder if that could be considered, whether there was a mechanism to inform the registrar that is there, and then the registrar contact the secure lender? Because it seems to me as an individual, if my home address ends up on here, for me to have to go through that arduous route to correct the record seems a bit onerous.
Yeah, because who committed the correction is limited to parties that are involved in the transaction. But to some extent, I suppose, yeah, it depends on that definition. Let's verify check.
It wouldn't be an inaccuracy as such, the inclusion of that detail, because the register wouldn't be incorrect in including that detail.
Correct, yeah.
But, we'll take that away and think what could be
Thank
done
you.
as regards that.
Thank you, Convener.
Thank you very much, Lorna. Do members have any other questions? Okay, I'm very conscious that members did have quite a lot of questions today, and I think a very helpful proposal from the Minister to come back in writing with a number of points. So I'm very much in members' hands whether you're content to consider each of the instruments before us today, or you wish to defer to next week pending that information. I'm happy to hear any views from members.
Yeah, my own personal view is that it wouldn't do any harm to wait a week, because I think a lot of detail has been brought out. That's my own personal view. I'm sure others would have.
Okay. Do members have any views, other views? So are members content to defer the next items to next week? Obviously, I request that the Minister and officials come back with the points that have been raised today, and consider some of those points and take the items next week. Okay, that's agreed. Thank you very much. Okay, so that will bring us to the end of today's evidence session. Can I thank Minister and his officials today for joining us, and that commitment to come back with a number of points that members have raised, hopefully to allow us to consider those items next week. And I suspend the meeting and move into private session.